Oh, here's
006761.
present. Can you see me?
President or present?
Present. Can you hear me?
Yeah, is that Mr. Elman?
No, Jason Elman here.
Okay. Okay. And Mr. Johnson?
Yes.
Thank you. All right, this is before the court on a 7-day notice to pay rent or quit. If I can have each of you sworn in, please.
Oh, 1 second. 1 second, sir. Oh, 1 second. Did you not get the notice that I was not served property?
I did.
So, and we're going to still go through with this.
Pardon me?
We're still going to go through with this, even though I was not served property.
I'm going to swear you in right now because am I supposed to just take at face value your written document?
No. No, but I mean, is he not?
There's nothing behind it, so we're going to have you sworn in, and we're going to have probably have a full hearing here. We'll see. It'll be interesting. Okay.
Please raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Oh yeah, I do.
So Mr. Johnson, I will address that. I know you stated that you got something in the mail, but nothing on the door, and nothing personally served. The service issue is a little bit difficult for the court to address because anybody can say, and I'm not telling you they did or didn't do it right, but anybody could say, I didn't get service. I do have an affidavit from you, which means you got something. I think the statute was written, you know, initially they try or required to try to personally serve. If the individual's not there, they can serve someone else of suitable age, or if no one's there, they can post and mail.
Yes.
I can't tell you what a lot of people use the constable. I can't dictate what the constable does. I don't know if they actually knock on the door or if they just post and mail. I can't tell you.
Yes, but I have cameras. I have cameras.
Okay. All right. So, but bottom line is, I mean, I've got Mr. Elman. Who do you use for your service?
West Coast Process Service.
West Coast Process Service.
Okay,
They're a licensed processor.
So they use a licensed processor who's saying they served you. I know it wasn't a personal service. You know, I think it's not. I don't want to say uncommon, but I wouldn't be surprised if some, kids or
No. Again, I have cameras at my front door.
I get it. So you have watched for what period of time?
Whatever day the 13th, I was home. The 13th, I was home because I just got the vaccinated shot, so I was actually feeling the effects of it. So I was home that day.
Okay, well, so I'm not going to view hours and hours of your video.
I didn't say hours and hours.
I don't have the time to do that. I understand you're testifying that they didn't. You've watched the video. I have a process server who's licensed. Their license is at stake if they're being untruthful. Who says they posted it? But the bottom line, when it comes down to it, is you got a notice and you have responded, and so the due process is moving forward.
Oh no, I mean, so you're saying that even though that they say that they posted it, even though they could take a picture at the door saying they posted it, you don't have no proof of that, but you're going to go through with the due process even though they didn't follow the procedures.
I have a licensed process server who has signed a written statement representing that they posted it on the door. So what happens is I get into this dispute, okay, and I'm not going to send this to a formal eviction for a full hearing on the service issue when you have timely responded with an affidavit. It is a matter of practicality for the court. Okay, everybody's expertise with camera work and doctoring dates and things like that. Bottom line, I got an affidavit from you contesting the document. Okay, so I just am not. I'm not telling you I disagree with you, sir.
Oh.
But if this court had a full-blown hearing for every individual who said I didn't get proper service, it would bring to the court to a standstill.
Well, I mean, but if I gotta provide evidence to prove that.
I'm done on the issue, sir. I'm done on the issue. You have filed an affidavit, and you're being afforded a hearing. That being said, there's an eviction out there, Mr. Element, and you could have filed your challenge in that matter. It was a 30-day no cause. It was case ending 1747. It was stayed to the end of the moratorium. I'm not faulting you for necessarily filing this, although it's somewhat duplicative. If your challenge in this matter would be successful, I presume it would be successful in the other matter, and wherein you already have an eviction order. I state that, frankly, I think the language is until the end of the governor's moratorium on May 31st, although I'm not sure that a lockout would be appropriate as to that eviction order until after the CDC moratorium runs.
Well, we'd like to argue doesn't qualify for protection under the CDC.
I don't qualify. Okay, I provide my qualifications.
Okay. Well, so go ahead, Mr. Elman. The first issue today really is the challenge, right? And your challenge is based upon his email that states it was he was planning to pay for months in advance. I think that's what you base your challenge on. Is that right?
That's part of it, and then with the new information that was supplied yesterday, there's some other things in there. His boss said that he had asked to be removed from the schedule. So if he's asking not to work,
I didn't ask to be removed.
Doesn't quite make sense to me. Another thing is he has been collecting.
Let me go to that just a second, because
sure. That's on page 21. The quote is, "We understand your situation, and I will
just a moment. I've got to go to the document. I was reviewing documents. Some of these don't upload. They don't for a while.
Gotcha.
Let's see if I've looked at this one or not. You said page what? So I've got a 13.
Page 21 is what showed on my end. There was like 40 pages yesterday. That Shane had
his documentation.
Yeah.
Correct. His documentation he submitted yesterday was 40 pages, and it'll be on page 21.
I do not.
Okay. What do you want to point out?
Well, from his boss, it says, "We understand your situation, and I will remove you from the schedule for now. We do not have any open shifts at the moment." So if he asked his boss to remove himself from the schedule, that's not having hardship due to COVID. That's asking not to work.
No, correction. I was sick that day, and they told me they.
Okay, I'm going to stop both of you. Only the governor's declaration ties the loss of income to COVID. The CDC doesn't necessarily. Let me ask you, Mr. Johnson, were you out of work for a period of time in 2020 or earlier this year?
Was I out of work this year?
In 2020 or 2021?
Well, yeah, I was out of work beginning in September. This was when I got sick, and also when I was able.
September of 2020.
Yes.
Through what period of time?
When I was sick?
Yeah.
Oh yeah, in September in 2020, and then in October I was calling and asking, when they're going to have more schedules. She said that there was not going to be there's no schedule right now because they actually cutting back.
So how long were you off work? Or out of work?
So they sent me home in September, and that was what the email was about, and they basically haven't called me back.
Well, I mean, there is this exchange in October. Have you gone out and looked for work? Additionally, it's challenging when I see you raise in your affidavit the habitability issue, but not check the box I'm a covered person and not have the rent on deposit. That's of course, to address the habitability issues, you must have deposited the rent into the court's escrow account
But
pursuant to statute. So I can't really address the habitability. You haven't included the rent.
but I paid from from July until January. I paid for 6 months, so there was no reason for me to deposit money into an escrow when I already paid for my rent.
Well, no, that was last year, right?
Yes.
Per the lease, it actually expired the end of December. It expired the end of December. That's all the prepaid rent was.
Yeah, but
Yeah.
but again, my also contestant is the fact that the lease itself was fraudulent. I mean, basically this woman.
Well,
Go ahead.
I've read that. I've read that, and that would be problematic for Miss Page, I guess, if she had done something like that.
And him.
But I have to strip this down. The issue is there rent due and owing? At least in this case, is there rent due and owing? And if so, from when? You say you believe it's 2 months rent, March and April. They say January and February. I think you were paid up with the 6 months prepayment up through the end of the year, I believe. Is that right?
Correct.
So I was paid up, right? And then, of course, now he just said that I was paid up to the end of the year, correct? So he sent me a no cause in November.
On the first one, yeah.
Okay.
November 5th. So if you're going to stay or fight, you got to keep paying. His allegation here is that January, February, March, April had not been paid, and I don't have any evidence or from you that you had paid that rent.
In January, if you remember from the last session, I explained that I was actually deducting the rent from January from the expenses that I provided him with the receipts of that the last landlord did not take care of, which of course could be used as a set off when they sold the place.
So that was before the court on a no cause, so I probably would have tuned that out somewhat. And so no, I don't remember. You got to understand, sir, how many eviction cases I see, so I won't recall what you may have posited in one case months ago. So it would be in your best interest to always restate your defenses.
And I did.
So, I mean, I see that you checked the box that said I corrected some habitability problems, but I don't have one 14-day notice from you, I think, that says timely back in January, hey, these are problems I'm going to withhold and or correct, and I don't have receipts for things that and maybe you filed in another case that wasn't a fair fit, so it wasn't an issue, because if you recall, the last one was a 30-day. Really, though, I still, the sole issue is whether there's loss of household income.
Judge, if I may jump in, he provided in his documentation yesterday on page 20 that he received over $18,000 in unemployment assistance last year. When I would imagine he's still collecting unemployment, and he hasn't made any attempt to pay rent, which is required under the CDC, that you have made attempts to do that.
God.
And that is correct. He's supposed to use best efforts to pay as much as possible.
But how can I pay when I'm paying all these court fees?
Sir, just a minute. So for 2020, that's a tax statement, right? That was filed, 18,000.
Yes.
in unemployment?
Correct.
For the whole year.
Okay, so the 18th, pardon me?
For the whole year.
It
When
started
did
at the end of March. If you look at
Mr. Elliman, stop, please. Mr. Johnson, when did you start receiving unemployment?
Back in June.
Why would that be? You didn't lose work, you said, until, I thought, September.
Yes, I was getting partial payments because I was first self-employed.
What were you doing self-employment wise?
I was doing like DoorDash and Postmates and all that other stuff.
Okay. And
Um,
so with 18,000 since June, but you were working from June through September?
Say again?
You were working June through September?
Yes, and I was getting partial payments because I was only part-time.
Okay. So you were working June through September, and you got 18,000 in unemployment last year. I guess that it's a reasonable question for the landlord to ask them why they haven't received any payment at all for since January.
Since January. Okay, so again, January was a deduction from the month that I could not. And you say that I didn't give them 14-day notice, but you're forgetting to include the fact when I don't have to give them a notice of what I'm going to deduct is when the landlord knew of the habitability issues prior to, the prior to me moving in. And the fact of the matter is, Jason knew about.
No, you've gotta provide that notice. If you're going to correct and deduct, you must provide him a notice.
This was on day one. This is on day one when I moved into the place.
Under another owner, right?
Yes.
Okay. But all that rent was paid, sir. So come January, when you're going to not pay them, you must provide them notice.
And I did provide them notice. I did. I mean, if you look on page, let me see. I provided them notice because I was trying to explain to them that I wanted them to back out of buying the place because I had an issue with the previous owner, and that's when.
So I'm going to ask a real practical question of you. Because I think if I'm, Mr. Ellman, recalling this matter, there's 4 units. You take over, you serve everyone 30-day no clauses on November 5th. Is that correct?
correct.
Okay. So I know Mr. Johnson said this is retaliatory and discriminatory. Mr. Johnson, Mr. Ellman, no relationship with him. He appears in front of me with some degree of frequency, and I know him mostly from no cause hearings or evictions where he has recently purchased the property, and they're going to renovate, and they're trying to remove everybody so they can get renovations done. Now you may say that's putting lipstick on a pig, and you may think he overpaid by $41,000 in this page. That doesn't matter. If he's a bad businessman, he can make those kind of deals. But he's entitled to try to fix things up and improve his rent. Okay? So one, I don't find this would be retaliatory. It's first of all a for-cause proceeding, and 2, he can fix stuff up if he wants. So at some point, we're going to get to the end of a moratorium, Mr. Johnson.
Oh, God.
Guess the question for me is you are fighting a valiant fight, but I guess my question is, at some point, we'll get to the moratorium, and then they can just remove. I mean, with no clause, whether it's the old one or start again. So I don't mean to suggest this is a game to you, but what's your end game? What's the end goal here?
Well,
some people I know don't want to get pushed around, or they don't want to feel disrespected. But there is an eviction out there. If people move out,
I am the only one.
Gets set aside.
I am the only one that he's trying to evict. I'm the only one he's trying to evict. You just asked him if he served everyone with 30-day notices, right? How many of those people has he evicted?
Okay.
0.
Okay.
There are.
Mr. Allen?
Go ahead.
Are you not moving forward with those, Max?
The people in Unit 3 moved out voluntarily after we served them a 30-day notice. The other 2 people in Unit 1 and 2, we ended up rehabbing Unit 3 and then signed a new lease with Unit 2 to move to Unit 3. I'll bring this up that they're African American just because he's filed a charge against us with HUD that is discrimination off of race and color. Then we moved Unit 1 into Unit 2 once we rehabbed it, once again also African American, and then we moved new tenants into Unit 1 that were also African American.
Mm-hmm.
But further, another thing, Judge, if I may bring up one more point, he did not apply for CHAP assistance until 3/20 of 21, and you can see that on page 23 of your documents.
Yeah, but
he filed a discrimination case against me with HUD on March 4th. So before he's even tried to secure funding to try and pay his rent, weeks before, he's trying to file a case against me with HUD. I feel like the priority should be backwards. You should be trying to get aid as soon as possible to pay for your rent.
Well, so that adds to the messiness of this case.
No, sir. Can I say something? No, that case with HUD.
No, you didn't hear me. What I'm going to disregard that. Okay, because I said that adds to the messiness of this case. There's just a lot of stuff hanging off this. My inclination on this is just a moment.
Oh my God.
Sir, did you apply for CHAPS on 3/20? Is that when you applied, Mr. Johnson?
I applied for chat once they started allowing people to apply again, because at the beginning of the year, all you received was notices saying that they was not accepting no new applications. Okay, I was checking back, and it wasn't until March I was able to get through. But of course, in his complaint for his reassurance for an eviction, he claims I made zero attempts to actually apply for CHAP when I actually notified him on April 1st.
Well, I know you applied on 3/20, so that is some effort, and I understand you weren't needing to pay anything at the earliest January. You would contend after that on some offsets.
Exactly.
So, let me ask you a question. Why no partial for March and April?
Say again?
Why no partial payments for March and April?
Because I was paying, let's see, he served me with 5 different complaints, $75 per complaint. I had to also pay for other legal fees. I got to pay for my food, my transportation, looking for another place. I had to pay for the appeal that I had to do to stay in the place, because for some reason, without any kind of motion from him, overturned your decision to let me stay until the end of the moratorium on the 31st, which I didn't understand. So that $250 plus $97 I had to pay, or I was going to get locked out, because it was done the next day. So this man received actually $250 because the appealing court, the appealing court was supposed to reverse and remand that order, because they, for some reason, believed that the case was based off of a nuisance order, which I don't understand when I look through your minutes.
I'll tell you, I fully believe that is an oversight by the district court. If everything else is styled as a no cause, I mean, you know, if it was nuisance, he would have.
Exactly.
Could have done.
But they determined that I was eligible for the moratorium.
Cut against you, so it was better that I mean, if it was a nuisance case and she found that to be the case, she would have said, and it was granted. There would have been no reason to stay it through the 31st of May, but that's what she did. Sua sponte without any input from me. So, but
but she's determined that I was eligible for the moratorium because I provided you when I applied for the eviction to stay and the motion to vacate. You know, the right. Can I finish? Okay, so I provide you with the right documentation to prove that I did qualify. So if they knew for some reason that this was for a no cause, she would have reversed and remanded. But when I sent them a order under Rule 60, it's for them to correct their clerical error. They said they didn't have jurisdiction, but they want to remand it back to the lower court. So you can take a look at it again and realize that I did qualify, and I do qualify, and that's one thing I don't understand.
And you were extended, put out. You were given time, right?
I was given time. I was. They said that I was qualified for the moratorium, which of course went to moratorium 43, which extended to the end of May. But what I've been trying to do, I've been trying to, find some kind of way to, make some kind of new arrangement with him when he became the new owner. But as you can see from the, I think it's page 32. See, I did not talk to Mr. Element until December 1st. But he clearly says here that he was not planning on renewing my lease. That was the month-to-month tenant. I was the only tenant that ever complained to code enforcement and all these other agencies. But I wasn't complaining on him.
I understand, but he still has the right to go in and fix it out.
Yeah.
So there may be some of those issues, and that might feel like he's discriminating against you. But I can tell you, he's done this with so many properties.
Okay, but sir, correct me if I'm wrong. Since this building is built 1963, right? He was supposed to give me some kind of notice in writing, let me know when he's going to be doing these, doing this work. He's also supposed to be pulling the permits for him because he's ripping up floors, he's doing plumbing, he's doing electrical, he's doing all this stuff. He has not pulled one permit, not one permit from the city, and I have that on record. So if he's doing everything on the up and up, then he should be pulling up permits. He should be letting me know that this kind of work is going to be happening, because this building, again, 1963, I have not got a disclosure.
I don't think he has any obligation to tell you how he's going to conduct the remodel. He does have an obligation to do it lawfully.
Yes.
But he doesn't have any obligation to say, this is my plan, and have you sign off on it.
But is he not supposed to pull the permits?
I'm going to find the following. I'm not going to move forward on this case because there's an existing case, and I don't like seeing cases doubled up on a tenant. Right now there is a eviction that the court had granted and imposed the stay through March 1st previously, and then it was extended by the district court through through May 31st. The court's going to find that there hasn't been any partial payments, and the court believes with the payment level of unemployment that something could have been paid by the tenant. So I'm going to find that the CDC order does not provide protection, meaning there will not be eviction, moratorium protection in June, but I will find that he still is protected under the governor's directive through May 31st, and so I'm going to call this case moot and deny it, and the eviction can move forward after May 31st in case 21E001747. That's the court's decision. Probably nobody likes it at all.
Your Honor, one quick question. Do we need to do anything else for that other case to go forward, or will the court send the order to the constable?
The court administrative order does state that the landlord must file a motion to reissue the order because it will, one, have been timed out, and two, that would only be necessary if the tenant has neither paid nor vacated. If he vacated, then that order would not be necessary, and the court will not be the one that, we're not going to issue 10,000 eviction orders just because they have been issued before, and we're going to, the court's requiring the landlord to step up and inform them that the matter is not resolved.
So the question, but one last thing, sir, before we go, again, since the case, since the eviction that was happening back in February, which I was actually denied because I was current with my rent, which doesn't make sense. The thing is, you said I was not qualified for the moratorium. The district court ruled that I did qualify for the moratorium, and that's what the whole thing was about. So why is he still granted an eviction when I'm qualified for the moratorium?
The upper court did not reverse the ruling, it just said it's stayed because the CDC order, if you go into the some federal cases, primarily one out of Ohio, it said the CDC order, the stipulation between the CDC and the Justice Department and the landlord was that landlords could move forward with the eviction, they just can't get the lockout during the moratorium. Okay, so in this case, the judge said May 31st, and that's what I'm holding to.
He said May 31st for a nuisance order, not because of no cause. It was because they thought it was a nuisance order.
Tell you that's Judge Eller, bless her heart. She was new to the evictions at the time, and she's made a lot of decisions that I think were not sound. I think she's gotten, for the most part, her arms wrapped around it. It was complicated. It's been a moving target for over a year at this time, and she has started to. Before, she was just denying them and saying you got to start over July 1, and there's nothing out there now that says that's what the case has to be. They can challenge, and then it's just the lockout can't come out. So I'm following that directive. It's May 31st. After that, if you're not out, they can move forward with the eviction. Frankly, if you're out before that date, I might be willing to just steal it.
Oh, okay, well, here's my last question, sir.
Nope, I'm done taking questions. I've been taking a long time with this case. If you don't like my decision, you know. But in this case, of course, the case is going away. We're just relying on the prior case. Okay. Thank you. Good luck, gentlemen.
Thank you.
AC 73600 Swenson owner versus Stephen Bonner and Rakisha Willis.
So you heard that?
Landlord. Thank you.
I'm off.
That wasn't a great start for the day.
I thought my client was going to be logging in.
You have Selena Corona online?
Hey, okay, you hear me? You hear me?
Yeah, I heard you.
Uh-huh. Motherfuckers.
You
see that shit?
Yeah. I said they said I qualify for the moratorium. So why do you still give him an eviction? You're like, oh well, because in Ohio.
Yeah, he that motherfucking friend.
Yeah. But legal aid actually tuned in.
Shannon, what they say?
So his eviction today was denied. And
so his eviction today was denied.
Yeah.
So he can't get kicked out.
no, not today. Not today.
Not today. He said not today.
Not today. Not today, Satan.
What is the reason for the eviction that the man kept saying? What is the reason that he's trying to evict you? He didn't give no proper cause. Why you?
And then I heard the man in the background talking about the other tenants are African American.
No, they're not.
They're African American. He's a motherfucking liar.
Yeah. And he remodeled all the places. And then I said, hey, so if he's supposed to remodel these places, is he not supposed to be pulling the permits? So if he's not pulling the permits, he's not doing things lawfully. So the fact of the matter is, why are y'all, and plus the lease in itself is not, is not enforceable for him to ask for money. So you're saying that this guy can take over,
Right.
Take over this place, knowing that there's other people I'm trying to go after, right? And then kick me out for them because they can't do it themselves.
Right.
But he can do that. That's fine. But I'm supposed to pay him all this money.
Hell no.
All the time you've been there, paid all the money though.
That's right.
I know, and I said, and the money that, I said the money.